This case kicks off with a judge who is clearly not in the mood for excuses, and a defendant who's already used up her second chances. What started as a probation opportunity for a robbery charge quickly spirals into something much more serious. We're talking about missed conditions, refusal to comply with court-ordered programs, and a judge who's about to make one thing very clear. This courtroom is not a place where you negotiate your way out of consequences. But here's the twist. What seems like a routine violation suddenly turns into a harsh prison sentence. The real question is, did she push her luck too far, or was this outcome inevitable? Stay with us, because this one escalates fast.
This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there.
She did not want to participate.
All right, so you can participate at the prison, but it's not going to...
American Justice Files.
Calling 2023 CR 4230, State of Texas versus Darianne Renee De La Rosa. Are you Miss De La Rosa?
Yes, ma'am.
Are you the same Darianne Renee De La Rosa who was placed on deferred adjudication in 2023 CR 4230 for the offense of robbery on July 17, 2023 for a term of 5 years? Is that you?
Yes, sir.
State?
Yes, Your Honor. Violated condition number 56 on or about the 30th day of January 2024 in Bexar County, Texas. The defendant, Darianne Renee De La Rosa, the then and there failed to comply with the rules and regulations or instructions of the Bexar County Supervision and Corrections Department's duly diagnosed residential facility, and the defendant refusing to participate with the required program violation number 56.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of 56, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition 56?
Yes.
Court will find it true. Is there a proposed agreement?
There is, Your Honor.
Yes.
Right here is where things start falling apart for the defendant. The judge isn't just reacting emotionally. There's a legal foundation behind this frustration. When a court orders a specific rehabilitation program like DDRF, it's not optional. It's part of a structured alternative to incarceration. By refusing to participate, the defendant is essentially signaling noncompliance with the very conditions that kept her out of prison in the first place. And here's the bigger issue. Probation isn't a right, it's a privilege. Once that trust is broken, judges often respond swiftly to maintain authority and deterrence. So ask yourself, should the court have given her another chance? Or is this exactly how the system is supposed to respond when someone refuses to follow court-ordered rehab?
And is to keep the individual on her probation and deferred to deny the motion and alter and require her to attend safety.
Okay, why is she not going to DDRF? That's my question, because that's what I ordered.
The information that we received from DDR was she did not want to participate.
All right, so you can participate at the prison, but it's not going to be at Safe P. This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there. So what's going to end up happening? You've been here before. The court is going to find you guilty. Now, how much prison time do y'all want to ask for?
Judge, the state originally maybe requesting 5 years, Your Honor.
I would ask for 2, Judge. She's willing to go to Safe P. She wants to continue with drug court. We would ask that you reconsider and consider Safe P. We understand that's going to be 9 months long with aftercare. She's willing to do that.
Okay, this is what the court is going to do. As previously stated, the court is finding violation of 56 true. The court will find you guilty. There is to be no contact with Monica Tobias. Court is going to find you guilty. Court is going to sentence you to 8 years in the prison. Court will give you credit for any time served. The record. So, Ms. De La Rosa, when you're sent to certain programs, I'm not just doing it because, hey, let's just do this for no reason whatsoever. There was a reason you were sent to that program. You do not get to write your own programs. If you could write your own program and be successful at it, you wouldn't be in court. All right, good luck to you. Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yeah.
According to the plea, punishment is to be assessed at 7 years in the prison. Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest? The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Your Honor, in the interest of justice, we would ask that the court consider moving forward with sentencing today. Ms. Rios is interested in beginning the process of putting this whole matter behind her.
All right. The court, Ms. Rios has some concerns or questions. Right. Do you have some type of mental diagnosis in your past? What's going on with you?
Yes. Right now I'm on Zyprexa Zola
For what?
for like anxiety and schizophrenia.
Okay. All right. When you're released from prison, do you have a case manager or someone who can help you stay on your medications?
Yes.
All right. All right. I'm going to follow your agreement. I'm going to find you guilty. There's an affirmative finding of deadly weapon. Sentence you to 7 years in the prison. I'll give you credit for any time served. All right. We can go off the record. You're going to have to make sure you stay on your medications, because if you come back to another felony court, depending on the nature of the offense, your minimum sentence is going to be 25 years. You understand?
Yeah.
All right. Good luck to you.
This case is a textbook example of how quickly things can escalate when court orders are ignored. The defendant started with deferred adjudication, a chance to avoid a conviction altogether, but failed to comply with a critical condition. That decision alone shifted the judge's approach from rehabilitation to punishment. The result? An 8-year sentence in one case, followed by a separate 7-year sentence tied to a serious aggravated assault charge involving a deadly weapon. The court also took into account mental health factors, which is why you heard discussion about medication and treatment continuity, but ultimately, accountability still took priority. From a legal standpoint, this highlights two key realities. First, plea deals and probation come with strict obligations, and second, judges have wide discretion when those obligations are violated. Now we want to hear from you. Do you think the judge was too harsh, or was this the consequence of repeated noncompliance? Backhand index pointing right if you found this case as shocking as we did. Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.